all rise. Her Honor, the Court of the United States District Court for the District of Alaska is now in session. With the Honorable Sharon Gleason presiding. Please be seated. Your Honor, on record in case number 3:25-CV-90, Darden versus Municipality of Anchorage et al. Please state your appearance for the record, starting with you, Mr. Darden.
Dustin Darden, appearing pro se for plaintiff.
Nick Milley for the defendants.
All right, very good. And we are here on the motion to dismiss the oral argument. I've also reviewed the motion to strike and the motion to supplement. I guess I had a question on the motion to supplement for the Muni, and that is, do you take issue with the accuracy of the transcript itself, setting aside the additional briefing?
Your Honor, it's been a minute since I've looked at it. There is additional information there. At the very least, there's a transcript from the dash camera video from Sergeant Knowles' vehicle, which was not submitted. So there's certainly additional information. And if I remember correctly, there are accuracy issues. I would commend the court to review the video, which speaks for itself.
All right, very good. Well, that was one question, and then the other question is, as best I could tell, the name of, there's a redaction of the name, and that's not evident anywhere. Is it the Muni's position that that's a different person than Mr. Darden?
Yes, Your Honor.
All right, Mr. Darden, do you agree that that's somebody other than you, that name that's redacted?
Your Honor, there's a redaction of the name when they were speaking to me, and there's also redactions of the individual they were issuing a moving violation to.
All right, and you don't take, when they said we thought you were redacted, do you agree that well, you heard it, that they didn't say your name, they used somebody else's name?
Yes, Your Honor, I would agree with that. That was what they furnished me originally, was the video with the name being redacted.
All right, now I'm asking, is there a dispute in your mind? Did they say, oh, we thought you were Mr. Darden, or did they say, oh, we thought you were Mr. Jones or Smith or something? You heard it, you were there, so...
Could you repeat that, Your Honor?
Yeah. My question is, when I don't know this redaction, my question is, when you heard the officer say, oh, we thought you were, and I'm paraphrasing, we thought you were X, did they say, we thought you were Darden, or did they say, we thought you were someone else?
From what I gathered, there was a portion where they thought I was someone else during that portion.
Okay.
But there's portions that are still questionable. But yeah, to answer your question, yes, Your Honor.
All right. So
they're speaking of someone else.
All right. That was not entirely clear to me. All right. Well, then I think we're ready to proceed. Mr. Mendolia, go ahead on your motion.
Good afternoon, Your Honor. May it please the court. I'd like to reserve about 7 minutes if that's possible. I'll try to keep an eye on the clock.
All right.
The court should dismiss this case in its entirety because Mr. Darden's complaint and the video that he asserts he incorporated in it don't plausibly show any entitlement to relief. I know there are a number of claims for the court, so I want to be responsive, so please interrupt me at any point. But I'd like to start with what we know from the incorporated video, which is, in 2023, Mr. Darden was arrested for approximately 4 minutes when officers mistook him for a different individual who had outstanding warrants. And as Mr. Darden just suggested, there's no dispute that when officers were speaking to him initially, they were using a different name. So Officer Maldonado pulled over a vehicle in the Romig Middle School parking lot, and Mr. Darden approached while Officer Maldonado was conducting a traffic stop, recording on his phone. Upon seeing Mr. Darden, and this is in the video at about 6 minutes, 6:20, Officer Maldonado glances up, and he says into his radio, I've got blank here recording me, and he asks for a backup officer. Then, as the the stop continues, and this is about 8.
Why can't we, is there some policy or something why we can't have this name in the record?
The reason it was, I submitted what was released to Mr. Darden pursuant to his public records request. My name was redacted as part of that public records request because APD has obligations under the Alaska Constitution's Privacy Clause to protect the privacy of third-party individuals. Certainly, if we reach summary judgment, which I don't believe we need to, but if we reach that stage, we would be submitting an unredacted video. In fact, it would be very helpful at this stage if that name were in the record.
Well, because how do I know? I mean, I'm hearing both sides agree. How do I know that the officer didn't say, oh, I've here got Dustin Darden? I mean, I don't...
Well, you have my declaration in the record, Your Honor, and I think that's at docket 28-2. But I suppose you'd be relying on statements from counsel. But I think it's a fair inference as well from what we see in the video. I think this is at minute 15 in the video, and I don't want to skip too far here because I do want to return to the part where the dispatcher sort of notifies the officer about the warrant, but to briefly skip ahead, Mr. Darden says, you're assuming my identity, you're saying I'm blank. Obviously, in that instance, he wouldn't be saying, you're saying I'm Dustin Darden. So I think it's a fair assumption from the video, and I don't think that's any obstacle to the court sort of concluding that officers misidentified Mr. Darden initially when he arrived at the scene.
And where is that pled in the complaint?
So Mr. Darden doesn't assert in his complaint that there was an unreasonable mistake of identity. What he asserts is that officers retaliated against him and arrested him for his speech. He was criticizing APD, and he made a statement about his religious beliefs.
So, but here I'm on a motion to dismiss, looking at the complaint. I agree that I can look at the video as well on a motion to dismiss without converting it to summary judgment. But it sounds like you've given me one but not both videos?
Yes, Your Honor. We can submit Sergeant Knoll's video. It captures the same scene from a different angle that doesn't... it's not head-on, so we submitted the video that we thought would be most helpful, but we could certainly supplement if it would be helpful.
So you're saying if and I'll be candid, I have not had the opportunity to watch the video at this point, but you're saying if I watched that, the only reasonable inference I could make was that there was a mistaken identity?
Yes. So Officer Maldonado glances up, he says, I have, so-and-so here recording. And then, while Officer Maldonado is still at the window of the vehicle conducting the traffic stop, he's speaking to a teenager, you hear over the dispatch, and you may have to sort of raise the volume and watch the video several times because it is sort of quiet. But the dispatcher says that Mr. Darden has a quote at 98 out of Palmer. And while I was not able to find a judicially noticeable source for Anchorage Police Code 98, it's very apparent later in the video that they're referring to warrants. Later in the video, Sergeant Knoll arrives and says, we're here, I'm arresting you for open warrants. And he repeats that. So I think it's a fair inference that 98 refers to warrants. So this information comes before Mr. Darden begins speaking about APD's practices or his beliefs. The sequence of events is Mr. Darden approaches, Officer Maldonado speaks into his radio, misidentifies him. He receives information that there are open warrants and they're sending a backup officer. He releases the driver, and then he starts engaging Mr. Darden in conversation in order to keep him, sort of to delay him so that all the other officers can arrive. And at that point, Mr. Darden starts telling him about his perceptions of APD's constitutional practices and his religious beliefs. And then Sergeant Knoll arrives, they place him in handcuffs. And when Mr. Darden expresses confusion, they immediately start seeking to disconfirm their prior identification. So at minute 14 they say, we're arresting you because you have warrants. And he says, I don't have warrants. You're assuming my identity. You're saying I'm blank. And then Sergeant Knoll and Officer Maldonado ask him several times, I wish for you to be blank. are you saying you're not, is one at one point. And then they ask him, what is your name? And that's at least twice. It's only when Officer Maldonado conducts a standard search, he reaches into his pockets and he pulls out his wallet, he sees his license, and he quickly goes to the vehicle and runs it, and then he comes back out and releases him from the handcuffs. And as he's releasing Mr. Darden from the handcuffs, Mr. Darden sort of exclaims, like, what's that needle? And they quickly show him that it's a handcuff sheet. They're not poking him with anything. And the whole period from handcuffs applied to release, I counted 4 minutes and 8 seconds. So all these actions are consistent with a reasonable mistake of identity. It's what you want officers to do when they make a mistake. They calmly seek information, disproving their prior identification. They quickly confirm that it's not the individual they thought it was, and when they release him, they apologize. More importantly, it's inconsistent with the theory of liability that Mr. Darden alleges here. He asserts that the warrants were a post hoc justification for his arrest. But we know that, from the video, that dispatch told Officer Maldonado about the warrants before he was handcuffed. He also alleges that they were retaliating against him because of his speech. But we also know that the notification about the warrants came before Mr. Darden began speaking about his, beliefs about APB. And at this stage, at this procedural stage, Mr. Darden's burden is to show plausible claim to relief. And in Twombly, they say that the plaintiff must plead facts that are more than merely consistent with liability. You have to nudge the claims from conceivable to plausible. So, on the bare facts of the complaint, it may be conceivable that the officers harbored some sort of ill intent. That's sort of contradicted by the video, but taking the video and the allegations together, that interpretation of events is not plausible. Twombly also instructs that the court should consider judicial experience, common sense, and other likely explanations. So I think sort of the core constitutional claim here should be dismissed on that basis, and from that, a lot of the other claims will follow and be dismissed. So the Minnell claims would come out. And I also want to point out, at the very least, we've asserted that the officers were protected by qualified immunity, and it was at the very least Mr. Darden's burden to allege a constitutional violation that was clearly established. And at the very least, they had reasonable probable cause to make the arrest because of the notification that he was subject to warrants. Or not Mr. Darden, obviously, but the individual who thought they were engaging in.
So where on the video would I find the phone call to dispatch about the outstanding warrants of this mystery person?
So at 8:28 in the video we submitted, you may have to raise the volume and listen sort of carefully.
But it's at 8:28. And so I'm looking at the transcript, which I realize I have not ruled on, but it's showing at 1:23 that Mr. Darden was placed in handcuffs.
That must be from the Sergeant Knoll video, because Sergeant Knoll arrives later than Officer Maldonado, or it's inaccurate.
So you're saying he was not placed in handcuffs until after the call with dispatch, and if I watch the video, that'll be clear.
That should be crystal clear, yes.
All right. So the 8:28 includes the stop of the teenager?
Exactly.
Okay.
The beginning of the video is Officer Maldonado pulling over the teenager in Romeo Middle School.
Right.
And in the video that we submitted, Mr. Darden doesn't arrive until about 5 minutes in.
Okay, all right. All right. So the first 5 minutes, when you say 8:28, really, the involvement of Mr. Darden is not till 5.
Correct. You can probably skip ahead, although I think the first 5 minutes, I think, show sort of exemplary misconduct and further support sort of the reasonable actions of the officer. moving on from the Fourth Amendment, unless you have further questions, Your Honor.
No.
At least the search and seizure and retaliatory arrest pieces. I want to talk briefly about excessive force. So there are 3 allegations of excessive force: the handcuffing, physical restraint, and then the allegation is that Mr. Darden, quote, felt what he believed to be a needle or sharp object. But the video shows that that's pure speculation. In fact, the officers were releasing him with a handcuff to the key. So I think, for the reasons we've argued in the brief, that handcuffing and physical restraint are routine in an arrest situation. They're an excessive force. And then this third allegation is just simply speculative. And we're not, at this stage, it's not a factual determination about what happened, but it's implausible based on the video, which we treat as another allegation. The claims, the Minnell claims, the other claims against constitutional defendants should fail because they're parasitic on the constitutional violations, but there are also separate reasons which we've discussed in our brief, and unless you have questions, I don't plan to discuss them today.
No.
Also, the state common law qualified immunity should apply to all the state tort claims. If federal qualified immunity applies, the Alaska Supreme Court has been clear many times that state law follows federal law, so those should be dismissed. But even if you decide that federal qualified immunity does not apply, the question here is, state common law qualified immunity would apply unless the officers acted correctly, maliciously, or in bad faith, and for the reasons I just discussed related to the video, that's not a plausible takeaway. And then finally, I want to talk about the public records claim. So, Mr. Darden says he requested dash camera footage and then also recording of his phone calls with the internal affairs folks. The dash camera footage, as you can see, was released to Mr. Darden with minimal redactions, and those redactions were to protect the privacy of a third-party individual. And then the phone calls were withheld and properly withheld under the A6C exemption. In the Porsche case, which we cite, it discusses this exemption, which is for documents or records that are compiled for law enforcement purposes and could be reasonably expected to constitute the unwanted invasion of personal privacy of a suspect, defendant, victim, or witness. So here, Porsche is clear that internal investigation documents are law enforcement records. And here, what Mr. Darden has requested could reasonably expected to invade the personal privacy of suspects, defendants, victims, or witnesses. Mr. Darden here submitted an internal affairs complaint. He is the victim, and while he is disclaiming his interest, he wants to waive his protection. There's an interest in upholding a categorical rule. Many victims wouldn't wish their IA documents to be released, and once we release, Alaska law doesn't have a case on point for this principle, but Alaska law follows FOIA law, and once the document is released pursuant to public records request to one individual, it becomes releasable to everybody. So victims have an interest in these internal investigative documents being protected. And the people against whom the allegations are lodged, even if they're unsubstantiated, which was the case in Porsche, they have a privacy interest as well. And then a final note on leave to amend. We said that there's no need for leave to amend, and Mr. Darden agreed. He said he has nothing new to offer. He wrote at page 23 of his opposition, any amendment would merely provide more detail supporting the constitutional violations already established. He says he doesn't have anything new or different to offer, just more granular detail on the same things. And I think for that reason, leave to amend would be futile. So unless the court has...
Not at this time. Thank you, Mr. Mendolia. Mr. Darden, go ahead, please.
May it please the court, Dustin Darden, appearing pro se for the plaintiff. I just came to the knowledge that Noel's video was not submitted before the court, so I've adjusted it appropriately. Is there a focus button on the...
There you go. All right.
Your Honor, under Ekbal and Trombley, my allegations must be taken as true. Defendants bear the burden of showing that no set of facts could establish relief. They cannot meet that burden. Start with what they don't dispute in their motion. I voluntarily approached Officer Maldonado. We had a 15-minute peaceful conversation. I openly recorded everything. At document 33, Exhibit A, transcript of videos filed 10/16/2025, page 18, line 4, right here it says, Darden addressing FTO Maldonado. Could you write him a citation? For speeding. 11 seconds later, they handcuffed me. I had 0 warrants. At page 19...
So let me ask you, do you agree with the municipal attorney's assertion that the officer had called dispatch and gotten this information about an outstanding warrant before this conversation?
No, Your Honor.
All right.
And
would you agree that if I watch the video, I'll be able to answer that?
from reviewing the video, you'll see they had no definitive suspect with warrants.
You're not recalling any conversation between dispatch and Officer Maldonado?
It appeared they were making assumptions about someone with no definitive warrants, not certain of the name of who they were speaking of. With multiple, the person that they were alleging, they had different reports from what the officer wrote versus what they called on the radio. They didn't even know who they were talking about, Your Honor. No visible warrants existed, but if I...
Well, do you agree that Officer Maldonado contacted dispatch?
Yes, Your Honor.
Before you were put in handcuffs?
Yes, Your Honor.
All right. And there was a conversation?
Yes, Your Honor.
What's your understanding of what that conversation was between between the officer and dispatch?
The conversation started that we had blank here recording and filming. So it sets a premise of retaliation by nature that they had someone that was recording and filming the officer. That was their initial call. And
it was not you that is the blank person?
Correct, Your Honor.
All right. And then did the dispatch say they're outstanding warrants?
They weren't. From what I gathered, I couldn't find any definitive warrants were actually established at any time during the video. And it's clearly in the video that they didn't know if there was any warrants for the person that they were alleging warrants.
All right. Well, obviously I have to listen to that because I think there's a disagreement of what dispatch said to the officer. So I'll do that.
Okay.
But you're saying here today that if I listen to that, the dispatch did not tell the officer there were outstanding warrants for this mystery person?
They were uncertain if there were warrants existing.
Okay.
Including the officer's own admission, they didn't know what warrants were existing. You'll see that in the video clearly.
Well, there's a difference between what the warrant was for and whether there was a warrant.
Okay. They made an assertion that 3 warrants existed, that I had 3 warrants.
Okay.
Okay. May I continue?
Sure, go ahead.
I requested Sergeant Moby cited for speeding. 11 seconds later, they handcuffed me. I had 0 warrants. Page 19, line 18 and 19, I invoked my right to counsel. And critically, on page 23, line 11 and 17, Sergeant Noel admitted, I did not ask for identification before arrest. Under Rule 8b6, allegations not specifically denied are deemed admitted. These undisputed facts defeat their motion. Your Honor, fugitives don't voluntarily approach uniformed officers and spend 15 minutes discussing constitutional rights. They don't identify as a Christian explaining Jesus Christ gives them courage to speak truth to power. They don't openly record while criticizing police tactics. Yet I had all of these. My behavior proves no reasonable suspicion existed. Officer Maldonado watched for 15 minutes performance. If he genuinely believed I had warrants, that belief was objectively unreasonable under Hill v. California, 1971. You cannot reasonably suspect someone is evading arrest when they do everything possible to engage with law enforcement. Your Honor, this is where the defendant's motion fundamentally fails. This is professional malpractice masquerading as qualified immunity. Sergeant Knoll commanded traffic division. His job, his daily function was writing traffic citations every single day. Multiple times a day, he performed this one basic task correctly. Identify verification. License and registration, please. That's identity verification. He did this hundreds, perhaps thousands of times without error. Yet, he performed this task correctly that week of my arrest, probably performed it correctly that very day. But when he claimed I had 3 warrants, when he made an arrest rather than being issued a citation, suddenly forgot the most elementary step of his profession. Your Honor, imagine a surgeon who successfully performs appendectomies every week, but on the day he operates on the wrong patient, he claims no case law specifically requires checking the chart. Imagine a pharmacist who correctly fills prescriptions daily, but dispenses the wrong medication and argues no precedent mandates reading the prescription label. Imagine a pilot who lands at the correct airport hundreds of times, but one day lands at the wrong airport and claims qualified immunity because no case law had identical facts. We don't call these reasonable mistakes. We call this professional malpractice, and we revoke licenses. Police work is no different. Week 1, day 1, every police academy in America teaches same functional principles. Verify identity before enforcement action. This isn't specialized constitutional law requiring case precedent. This is basic job competence. It's the professional equivalent of a doctor washing his hands before surgery or an electrician turning off power before working on wiring. When a professional admits deliberately skipped procedures, he performs successfully every other time he does his job. Procedure, he performed correctly earlier that same day. That's not a reasonable mistake.
Mr. Darden, let me interrupt you and ask you, so is there a case you can point me to, a circuit case or Supreme Court case that says a police officer must try to verify identity before they arrest someone?
Yes, Your Honor.
And what is the best case you think?
There's 3 combined cases. Under Hope v. Pelzer, that deliberate choice to abandon professional standards.
No, I'm saying specifically on verifying ID. I understand your argument about it being a professional standard, but is there a case that talks specifically about verifying identity prior to arresting someone?
It would be Terry v. Ohio, Beck v. Ohio, and Hill v. California. And I can tie this all together for you.
Sure, go ahead.
Here's the abandonment. This is where the abandonment is particularly damning. Sergeant Knoll had ample time to perform his basic duty. This wasn't a split-second decision and dangerous situation. I stood there peacefully for 15 minutes. Officer Maldonado had been conversing with me. At any point during those 15 minutes, he could have asked the simple question, what's your name? 15 seconds to ask, 15 minutes available, 0 investigation conducted. Terry v. Ohio, 1968 established that seizures must be based on investigation. For 57 years, that's been the law. Not hunches, not guesses, investigation before seizure. Beck v. Ohio, 1964 established arrest required probable cause. To have probable cause, the specific person has warrants. You must first know who the specific person is. And then Hill v. California, 1961 established that identity mistakes must be objectively reasonable, but a mistake cannot be reasonable when the professional made no attempt to accuracy despite having both the training and the opportunity to do so.
Are you reading there from the case, or is that your argument?
That's my argument. Okay. I can go deeper into those 3 if you would like.
No, that's fine.
Okay, but Your Honor, These three cases, over 50 years old, converge to make one requirement unmistakably obvious. Officers arresting someone for warrants must first determine who that person is. It's not a novel constitutional law. It's the logical application of established principles to the most basic requirement of police work. Defense will argue Hope v. Pelzer requires a case with identifying facts. Hope v. Pelzer 2002 rejected that argument. The Supreme Court held officials can violate clearly established law even when novel factual circumstances when general constitutional principles make the violation obvious. Your Honor, in Beck, if Beck plus Terry plus Hill don't make obvious that you must identify someone before arresting them for warrants, then qualified immunity swallows the Fourth Amendment whole. Under defendant's theory, officers could arrest anyone, anywhere, claim mistaken identity, then escape liability by arguing no court specifically addressed their particular variations of professional incompetence. That cannot be the law. Your Honor, there's a procedural point defendants ignore. Cates v. Coley, 9th Circuit, 2018 held that dismissal on qualified immunity grounds at the pleading stage is appropriate only when the complaint itself demonstrates the conduct didn't violate clearly established law. Here my complaint alleges conduct that violated Beck, Terry, and Hill. Principles clearly established over 50 years. Whether officers' specific conduct violated those principles involved disputed facts, what they observed, what they knew, what the investigation they claimed to have conducted, why they acted when they did. Those are factual disputes, and they belong at summary judgment after discovery, not dismissal at the pleading stage. At this stage, taking the allegations is true. As the court must, the constitutional violations are plain. Your Honor, page 19, lines 18 through 19, I clearly state on video, I asked to speak to my attorney. Edwards v. Arizona, 1981 mandates that all interrogation immediately cease. This is black letter law. Every officer learns this at the academy. It's not ambiguous. It's not discretionary.
You don't have a Fifth Amendment claim in your complaint. Would you agree?
That is correct, but it backs up my 42 U.S.C. 1983 claim of protected constitutional rights that encompass the Fourth Amendment and the First Amendment.
Okay.
It's because I invoked counsel, they're claiming. So instead of ceasing interrogation, officers continue. What's your name? What's your name? They repeated this question multiple times after the invocation. This matters for two independent reasons. First, it's a separate Fifth Amendment violation established for liability. As you know, it's not an original claim. But second, it destroys their entire refuse to identify defense. Any purported refusal occurred after my constitutional protected invocation of counsel. Officers cannot continue questioning after Edwards' invocation, obtain responses during unconstitutional interrogation, and then use those responses to justify an arrest that already happened. The Edwards violation is proof that these officers knew they were violating my rights and simply didn't care. Your Honor, the Department of Social Services, Monell versus Department of Social Services, 1978 requires showing municipal policy or custom caused the violation. I allege three independent policy sources. First, training failure. The traffic division commander doesn't know traffic law. When I asked, why are you speeding through a 5-mile-per-hour school parking lot, he responded, isn't the limit 15? City of Canton v. Harris, 1989, recognizes when you need...
So, Mr. Darden, how does the fact that this officer may have been going above 5 miles per hour tie in at all to your claim of a Fourth Amendment violation?
Because it encompasses the competency that Sergeant Knoll, he was specifically in charge of traffic.
The violation that you're suing on has nothing to do with the fact that he was going too fast, in your view, in the parking lot, correct?
It does in a sense of the retaliation aspect, Your Honor.
All right.
That would be my argument.
Okay.
City of Canton v. Harris, 1989, recognizes when the need for training is so obvious and failure to train is likely to cause violations, that's deliberate indifference. Traffic officers not knowing traffic law is the definition of obvious training failure. Second, supervisor...
You're not seeking to recover damages for a training failure of somebody going too fast in the parking lot. They didn't run you down. I mean, that might be a valid claim, I suppose, but I'm at a loss to understand how, even if Officer Knoll didn't know the correct speed limit for Womack High Middle School, that gives you an entitlement to $250,000 in damages, or to the right to sue the Mune. I don't get that.
I understand your reasoning on the 5-mile-per-hour portion of it, Your Honor. And it's just, again, just to tie into the retaliatory aspect.
And I understand your argument there, that you believe that what you were complaining about was a cause for your arrest. I understand that point.
And I appreciate your perspective. Second, supervisory ratification. Lieutenant Davison reviewed all evidence, Knoll's admission, the 11-second timeline to handcuffs after asking for a citation, the Edwards invocation, and defended as proper police conduct. Christie v. Opa, 9th Circuit, 1999, established supervisory ratification on constitutional violations create municipal liability. Third, systematic concealment. This is a big one. The municipality refuses to provide public record. Your Honor, I respectfully request the court take judicial notice under Federal Rule of Evidence 201 of the Department of Justice April 2023 investigation, finding the Minneapolis Police Department available at justice.gov, and this is included reference in my claim. These are the official government findings, not subject to reasonable dispute, documenting that the Minneapolis Police Department routinely declined timely responses to public data requests and used procedural barriers to obscure misconduct, a pattern that undermined the accountability and violated state record laws. That's precisely the pattern I allege here. If that pattern required federal intervention in Minneapolis, it established municipal policy here in Anchorage under Monell. These aren't individual officer mistakes. These are institutional design, creating the conditions for constitutional violations.
So is it your argument that the municipality's unwillingness to give out internal investigation documents is unconstitutional?
It would violate federal and state precedent of readily available public records. And I could embellish.
So you're saying that all internal investigation of police officers should be fully public, that if a person calls...
Not fully public. As the court seals records for social security numbers, personal identification numbers, I believe there are private pieces of information. But I do believe that municipalities across the country willfully, like the Minneapolis Police Department, withhold the most crucial evidence, such as public officials operating in public with public funding against citizens. And I believe that things like collective bargaining agreements, where they're written in as clauses to protection, are overriding our freedom of information. And that's one of the fundamental reasons why this claim is so important. But
so what is it that you're saying you haven't been provided apart from your own communication with the lieutenant?
I appreciate that question, Your Honor. At this hearing today, I'm reminded I was under the impression Knoll's video was submitted to the court. And the fact that they didn't submit Knoll's dash cam footage, which showed the speed at which he was traveling in more detailed audio, is very disturbing and troubling to me, as though when I received the records, it was included. Now, the conversation with the lieutenant, who was acting as Lieutenant Davison, when I talked to him about the conduct.
So you've gotten the Knoll's video?
No, they did not provide the Knoll's video to me, only Maldonado's.
Okay.
And it was only partially unredacted. Now, I got it in the records request, the Maldonado video, originally, but it was heavily redacted.
But now you've gotten it pretty much unredacted, except this name issue.
Just Maldonado's. They did not give me Knoll's.
Okay.
So Knoll's...
Did you ask for Knoll's?
I asked for Knoll's. And the fact that they're hiding it intentionally, and the conversation with Davison, is very troubling, because Davison was acting as lieutenant, and now they're writing that he was acting as an internal affairs investigator. So something's very suspicious And
All right, so you'd like the Knowles video, and what else are you missing that you feel you're entitled to?
The Knoll video, all of the police report that they didn't give me Knoll's video. There's claiming that's private. No, Knoll's report, I'm sorry, Your Honor. They didn't give me Knoll's written report where he arrested someone as a sergeant who had no warrants. They haven't given me, they've given me very little.
Somebody else was arrested?
They gave me Maldonado's report, where they call it somebody else since discovery, but they've withheld everything under that's private.
Did you get an incident report for your interaction?
Just from Maldonado, not from Knoll.
Okay, and then what else besides that?
The full unredacted conversation with Lieutenant Davison, the internal affairs investigation, I'd like that. The conversations with dispatch, essentially everything encompassing this case, which they're claiming is secret information, which I'm not talking about social security numbers, I'm not talking about birth dates, I'm just talking about a citizen that felt like his constitutional rights were violated.
So I thought you don't have the dispatch communication? I thought that's on the Maldonado dash cam recording.
There's redactions through it, Your Honor.
But that's just the name of the person that we all now, it sounds like, agree is somebody other than you.
I can't speak to all the redactions they've made, but okay. I just like a clear, unless something's sealed for the court, I know the court's respect for private information. If it's not, and I really, there's a portion of the records, there's some portions of this that tie this whole thing together, if I may.
Go ahead, briefly.
Okay. Thirdly, so that's Minneapolis Police Department. Your Honor, the Fourth Amendment unreasonable seizure without probable cause, Fourth Amendment search of recording devices under Riley, Fourth Amendment excessive force under Drummond, First Amendment retaliation proven by 11-second timing, the FOIA and Alaska Public Records violation, 3 municipal liabilities under Canton, Christie, Monell, state law claims for false imprisonment, assault and battery, IIED, intentional infliction of emotional distress, and negligent training under supplemental jurisdiction. Every claim properly pled with specific factual allegations, every claim cites controlling legal authority, every claim survives dismissal. Your Honor, defendants submit video in the reply. The court considers the video under Rule 12D. Procedural fairness requires considering the transcript, providing the full context. Alternatively, the court can exclude both and rely on the complaint allegations, which must be taken as true. Either way, I prevail. The complaint probably alleges violations, and their video actually helps my case by capturing Knoll's admission, proving the timeline, and documenting the Edwards violation. If dismissed, Alaska established that professional malpractice gets qualified immunity. Officers can abandon procedures they perform correctly every day and escape liability by claiming no one case had identical facts. That turns qualified immunity into absolute immunity for professional incompetence. It means the next traffic officer who arrests someone for warrants without asking their names gets immunity. The next officer who continues questioning after Edwards' invocation has no consequence. The next municipality that deploys 12 legal theories to hide misconduct records succeeds. That cannot be the law. Your Honor, as a pro se litigant, I've learned something critical. I'm not just fighting for my rights, I'm creating a record. A citizen whose constitutional rights are violated should not need to file a federal lawsuit and agree to seal evidence in order to get justice. These are public records documenting public employees performing public functions with public resources. If I allow that evidence to be sealed, I leave no path for the next victim. How can the next person arrested without being asked their name prove officers admitted this practice? If my evidence is secret, how can future victims establish Monell patterns? If my case is sealed, how can pro se litigants overcome qualified immunity if precedent is hidden? The systematic concealment of police misconduct through both administrative refusal and public records and judicial sealing orders creates an accountability void the Constitution cannot tolerate. I request that all proceedings, all discovery, all evidence in this case remain public unless defendants evidence meet the demanding standard for specific narrow protective orders with particularized justification. The default must be transparency. The Constitution demands it. Future victims deserve it. Let us put it on the record from this day forward. Conclusion, Your Honor, defense wants triple immunity, qualified immunity for officers who abandon professional standards, Monell immunity for municipalities who choose obstruction over accountability, and procedural immunity through systematic concealment. The Constitution does not permit layers of immunity that make violations unreviewable. Sergeant Knoll admitted he never asked for my name. The video proves 11 seconds from criticizing to handcuffs. I had no warrants. I invoked counsel. They ignored it. They seized my recording device. They refused to provide the evidence. They ignored 2 settlement offers documented at 10-6, 2025, Exhibit A and B, motion for hearing. I request judicial notice of this. They chose retaliation over investigation, concealment over accountability, gamemanship over justice. Every claim survives because every claim is proven by their own evidence and their admissions. I respectfully request the court deny their motion to dismiss in their entirety. If the court finds the material facts undisputed, Knoll's admission that he never asked for my identity, the 11 seconds timeline for an Edward invocation, and the lack of warrants, I respectfully request this court consider partial conversion to summary judgment under Rule 12D. On those claims where undisputed facts establish liability as a matter of law, I defer to the court's decision on timing and procedure, but I'm firm on this. The record we create must be public. The Fourth Amendment cannot mean so little. The First Amendment cannot be so weak. The Fifth Amendment cannot be so easily violated without consequences. Thank you, Your Honor. I'm prepared for questions.
Not at this time. Thank you, Mr. Darden. Mr. Mendolia, briefly.
Yes, Your Honor, I have maybe 3 or 4 points I'd like to make. So,
Sure, go ahead.
On the question of whether or not Officer Maldonado was informed of the warrants, I would ask the court review the video, and you can look at footnote 58 of our reply, which has the transcript, or, the transcript of what was said at 8 minutes and 28 seconds. And I think Mr. Darden's main argument on the Fourth Amendment is that the officers didn't ask him for ID before they handcuffed him. The Fourth Amendment's touchstone is reasonableness, and we pointed out that he has cited no case that says ID must be checked before an individual's handcuffed. What happened here is Officer Maldonado made a visual ID based on what he saw, appearance and behavior. So he saw an individual, and he saw him recording on his cell phone. There are several individuals in Anchorage who have that kind of practice. So Officer Maldonado made a mistaken identification.
What's your response to the argument Mr. Darden was making that a person that had outstanding warrants would not be likely to engage with an officer for 15 minutes about the Constitution?
I don't agree that that's always the case, Your Honor. There's often the case that individuals aren't aware that they have outstanding warrants. An individual might fail to appear for a hearing and a bench warrant might issue. Police officers might be given a warrant to search an individual or to arrest an individual, and they don't immediately go and perform it. So it's very conceivable that an individual might approach police officers and interact with them without knowing that they were subject to warrants. The cases he cites, Hope, Terry, and Beck, they're at too high level. Well, Terry and Beck are at too high a level of generality for qualified immunity, and the Hope obviousness exception just simply doesn't apply here. Dismissal is appropriate at this juncture because qualified immunity is an immunity from litigation and the burdens of discovery, and Mr. Darden's correct. He has to allege conduct that violates clearly established law, and that's not the case here. Quickly on 12D, the incorporation by reference doctrine is an exception to the 12D conversion rule. If this court believed it was necessary to convert to summary judgment.
Well, where I'm troubled, no, I agree with your reading of the law on that point, that it can include the video without converting in this circuit, but where I'm a bit troubled is that the video wasn't provided until your reply, and so it wasn't with your motion, and so that's why I'm on the fence there.
The reason it was included in our reply, Your Honors, because Mr. Darden requested in his opposition that it be included. So he was bringing it in as part of his allegations. So that's why we included it with the reply.
Do you think there's much difference between Officer Knowles' video and Officer Mendola? I don't know. I have so much trouble with his name. I apologize.
No, so there shouldn't be any difference. There's a brief period where Officer Maldonado steps inside his vehicle to run Mr. Darden's license, and his mic is inside the vehicle, so the conversation isn't captured. And we are very happy to submit Sergeant Knowles' video. That was likely an oversight on my part. And then on the issue of records, a lot of what Mr. Darden has raised here is not what I remember from the complaint being the subject of his public records request, and at least what was in the complaint. But what I did was I looked at the public records request from APD, and I looked at a technical report of the edits they made to the video. And what they did was they muted out the name of this third-party individual. And that's the video that is in the record before, Your Honor.
And are there other redactions that you're aware of?
I'm hesitant to speak out.
I will find out.
Yes, but it's possible that the third-party driver, there was a teenager who got pulled over.
Right. I think I did read a reference to that person being redacted as well.
And this would all, be available to Your Honor if we got to summary judgment. But it's not necessary to go there. And the officers here in this all have the whole doctrine of qualified immunity going back to Fitzgerald is to prevent the burdens of litigation. If I'm happy to answer any further questions Your Honor has, but other than that,
no, I think I'm good with both sides' arguments. Thank you both, and I'll take it under advisement and get you something out. I recall I stayed the discovery pending a ruling on this motion is where we're at. Am I correct there?
Yes, sir.
All right, very good. Then we'll go off record at this time.
All rise. This matter is now adjourned. This court stands in recess until 1:30.